Okay, so I think we will start now and then people will join as we go. So welcome everyone. I am Alissa Rabar. I am the advocacy and legal lead of the European Network of Migrant Women. We are a platform organization based in Brussels and gathering 50 member organizations across 23 European Union member states. Our members are small and bigger NGOs or service providers working directly on the ground with migrant women. So that's our specificity. Our work aims both at producing and conducting projects at the level of the European Union, so cross-border projects, and at enhancing and building the capacity of our members who are working in a very local context. With this, we also have advocacy goals, and we try to push for self-representation and promote the rights and interests of migrant women at the level of the European Union. And for this, we believe that the legal frameworks are a key aspect, and not only changing the laws and getting new laws that are efficient, but also properly implementing the existing frameworks and having them well known and used properly in the specific context and situations faced by migrant women. So this is also the interest and the purpose of this event today. Because we will be presenting our new report, which is called Women's Rights Perspective on the EU Charter of Fundamental Rights. So this was very important for us to, first of all, produce and also to present to you today. Because the EU Charter of Fundamental Rights is a very important instrument that will be presented to you later on today. But it's very little known. It's not very much used by legal practitioners across Europe, which led us to produce a project which is called Fulfil. And this project, which is funded by the European Union, aims at enhancing the capacity of 600 legal professionals across Europe, but also equality bodies, diplomatic missions, and law enforcement. It focuses mostly on France, Italy, and Portugal, and the aim is to improve the use of this charter in supporting specifically migrant women's rights. We also seek to empower 100 vulnerable migrant women across the EU and 50 civil society organizations working with them. We built a training program that focuses on the use of strategic litigation to better protect migrant women, as well as understanding migrant women as a target group and understanding the specific barrier that they face when accessing justice. And in this context, it was very important for us to produce this analysis of the EU Charter to just highlight that nowadays it's still being used widely with a gender blind perspective. However, we could use it to really tackle in a more effective way the situations faced by migrant women in Europe. I would like to mention the partners of this project, which are Olympe Association in France, Paroline Law Firm in Italy, Iroko Association in Italy as well, Association Against Femicide in Portugal, and European Women's Lawyer Association, which, like ENOM, is an EU-wide platform. The report that we are launching today, it gathers a legal, historical, and sociological analysis of the different articles of the Charter. And really our aim with this is to help to promote a shift in legal culture, moving from this gender-blind understanding that I mentioned towards an approach that is sensitive to women and girls' specific situations and needs. Or this work follows the publication 2 years ago of another report that can be found in the website of the European Network of Migrant Women. It's called Undocumented Migrant Women, a Neglected Chapter in Fundamental Rights Protection. It was conducted in partnership with Reuters Law Firm. And basically, it's a legal mapping of 9 EU countries of the gaps when it comes to ensuring the protection of fundamental rights of specifically undocumented migrant women and also migrant women who are at risk of losing their legal status. So asylum seekers, women in prostitution, women victims of domestic violence, and domestic workers. So I will not go too much in details about the report and the EU Charter because I would like to give the floor now to Mariana Cunha, who is co-author of the report. She's also a legal expert and she's the president of the Portuguese organization Association Against Femicides, which is a partner of the Fulfil project. So Mariana, the floor is yours.
Thank you very much, Alisa. It's a great pleasure to be here with all of you today. And I think I can speak also for the other co-authors, Alisa and Anna. We're very proud with this result and much needed. I'll give you a bit of an overview of the reasons why we decided to come up and to draft this report. And also a bit about the structure and what we want to accomplish with this document. But before, just a quick introduction. As Alisa said, my name is Mariana da Cunha. I'm the president of the Portuguese Association Against Femicide. And we're a small grassroots organization based in Portugal that aims to that works in the field of preventing and combating femicide. And we have a very specific focus as we are the only organization in Portugal working in these topics, but also supporting the families of the victims of femicide. Before I jump into the context of this report, I think it's also important to start from why did we came up with this idea of creating this such important analysis. And I would like to start with what is missing after all. So we realize that we're missing a women's rights perspective across all the articles of the Charter. There is no provision stating clearly the unconditional and fundamental principle of equality between women and men. And the provision should also not only prohibit discrimination on the grounds of sex, but also make the promotion of equality between women and men mandatory. We know that some literature already points to the weakness of the equality provisions, and we know, of course, there is a big gap between the so-called de jure and de facto equality. And the question is, can we see these dimensions in the provisions regarding women's rights? As you know, or as you may know, de jure equality refers to the existence of a legislation that actually addresses women's rights violations and the promotion of equality. And the fact we call it recognizes the different challenges that women face to fully enjoy their rights. And this is what we ask in the beginning. And also, how about violence against women? How about sexual and reproductive health rights? How about trafficking? How about prostitution? How about harmful practices or even femicide? It's also relevant to mention that the EU Charter is it's a living instrument that must be interpreted in the light of the present days in the light of present days conditions. So this is also important to mention, and hence the need and the importance of creating this analysis. So our analysis conveys a tool. It is a tool for legal experts and working in the field that can be consulted, and also provides a detailed picture of all the ongoing debates and the recent developments, legal instruments and jurisprudence within the thematic areas of the report, from the right to dignity, to the prohibition of torture, to the right to health. The Charter provides, of course, a legal basis to gender equality and has the potential to advance effective implementation on the fundamental rights and gender equality, but also to enhance the use and awareness of the Charter by national courts, legislators, administration, and law enforcement bodies. And what we want with this is for the Charter to be used to its full potential, and this is the big aim of this report, as my colleague Alisa already mentioned as well. And overall, this analysis aims to demonstrate how the Charter can be used by legal practitioners as a tool for advancing even further, or advancing equality between women and men, non-discrimination, also access to justice, but also as well as ways in which it should be improved, interpreted, amended, and used to provide a gender-sensitive approach to the specific needs of migrant women. And this is very important. We conduct a feminist critical legal analysis with the focus of the needs of migrant women, as well as, of course, women as a group, but this is our priority, which also reinforces the component related to one of our goals, which is this report, as I mentioned, can be consulted, and it's a very relevant tool for legal professionals and NGOs that work in the field, but it's also a call for action. And that's why we have several recommendations as well. It's a call for action, which is the motto to rethink the EU Charter and actually accommodate women's issues and blunt violations of their rights. Focusing a bit more on the methodology that we use in this report, the methodology takes a multidisciplinary and comprehensive approach to the analysis of the EU Charter from a women's rights perspective, from the perspective of equality between women and men, of the fundamental rights enshrined in the EU Charter of Fundamental Rights, specifically, and as I mentioned before, pertaining to the experiences of migrant women. So every article of the EU Charter is analyzed separately, and this analysis relies on not only existing studies, academic articles, grey literature, and what I mean with this is publications outside the traditional means of publishing and distribution, but also jurisprudence as well as human rights instruments for the protection of women's rights. In addition to these, where relevant, it also refers to the results of the Fulfil survey targeting legal practitioners across the EU on the use of the EU Charter to support migrant women, as well as interviews conducted with traumatology experts on the barriers faced by migrant women in the justice system and how this can contribute to their traumatic experiences. So in order to enhance the Charter's potential, the report also relies on several international human rights instruments. So we mean with this, we rely on treaties and conventions as well as soft law, which have either dedicated attention to the rights of women, including migrant women, or that deal with the rights of migrants as a group, albeit in a gender-neutral manner, but also relevant to migrant women. So we try to understand whether the provision corresponds to the international normative standards and recommendations that protect migrant women's rights. This is what we do in the analysis. And it is particularly relevant to the analysis, for instance, the Convention on the Elimination of All Forms of Discrimination Against Women, the so-called CEDAW, the general comments, concluding comments and views of the CEDAW Committee, the Istanbul Convention, and also relevant to these, the judgments of the European Court of Justice and the European Court of Human Rights. To tell you a bit more about the structure, so I focused a bit on the methodology, I would like to highlight how important for us is also the terminology. So the terminology is a key aspect for us when developing this report, because language matters, and especially when we want to pass a compelling message. And we also want to convey and harmonize language across the document. So that's why we refer to violence against women and girls. But besides that, of course, we want to also promote amongst policymakers, legal experts, etc., the use of a language that truly encompasses women's experiences of violence and inequalities, and this is very relevant for us. The report, as I mentioned before, puts forward key commitments in advancing women's rights in international law, generally speaking. So equality between women and men, which, of course, as we all know, it's a key value for European societies and the protection of women's human rights, and a priority, of course, for all member states. And of course, we aim to provide an overreaching view of the Charter's history, which is also a component of this report. So the Charter's history and its current interpretation in relation to some of the rights enshrined in the Charter. More specifically, as I mentioned, our focus is indeed the fundamental rights of migrant women. And it is very clear that migrant women face additional challenges and obstacles, barriers linked to their both being a migrant woman and female, besides other barriers that are related to their legal status, and the intersection of several systems of discrimination related to sex, race, ethnic origin, language, religion, belief, economic status, age, disability, and so on. So we know that migrant women face an increased risk of being victims, and I'll tell you a bit more about this later. And so that's why this is our specific focus, the human rights of migrant women in international and European Union law. Besides that, as I mentioned, we conduct a critical feminist analysis of all the articles of the Charter, hence the name Rethinking the EU Charter from a Women's Rights Perspective. So you'll find everything in this analysis of every article, but also we put forward final recommendations for policymakers in order to advance even more women's rights. And I'll also tell you a little bit more about this. It's also relevant to say, I already mentioned a little bit, but that the report indeed provides a comprehensive women's rights sensitive analysis of the fundamental rights enshrined in the Charter. Of course, considering women's persistent, far-reaching and widespread human rights violations. And we also have a specific emphasis on the intersectional and multiple forms of discrimination endured by migrant women, as I mentioned before. So even though every article analyzes a specific right or specific topic, we considered it was relevant to make connections with the other articles of the Charter, especially because most of the articles can be applied in tandem and also with the jurisprudence of the court, and they also mutually reinforce each other. We couldn't analyze every article. We ended up with a 70 pages document. So if we analyze all the articles, it would be even tricky to do it in a 1 year time, so to say, which is how long it took us to produce this document. So we decided to select a list of the most elemental rights enshrined in the Charter, even though, as I mentioned, we make connections to all the articles of the Charter. So yeah, we analyzed the key rights enshrined in this Charter, the main human rights violations, and the most flagrant violations the migrant women face. So the right to human dignity, right to life, prohibition of torture, and also the prohibition of slavery and forced labor, respect for private and family life, non-discrimination, equality between women and men, healthcare, and so on. One of the articles that is particularly relevant in this analysis is the prohibition of torture and inhumane and degrading treatment or punishment. This is probably one of the longest analyses that we have. And it's very important for us to pass the idea that, and some of you may already know this, but since 2008, the UN Committee has finally categorized several forms of violence against women as torture per se, torture that happens not only in the public, but also in the private sphere. And this is quite an important, remarkable advancement. So what this general comment says is that several forms of violence against women, namely domestic violence, female genital mutilation, rape, and trafficking are forms of torture per se. And so for us, this is a key article that we wanted to, so that's why I wanted to make a very comprehensive analysis. And so I'd like to give you a few points of the main elements that we included in this analysis. As you may know, the definition of torture is a foundational value in democratic societies and international human rights law. Some authors define it as a cardinal axiom of international human rights law. And The prohibition of torture contains a so-called ius cogens norm in customary international law, which means that no derogation is possible, or any norms in conflict with this are void. So this is very important for what I will tell you a bit more in this categorization of forms of violence against women as torture. We know also, when it comes to the historical framing of torture and the disparities when it comes to women's rights, that torture has, unfortunately, historically been interpreted from a male-centric point of view, where a male prisoner deprived of freedom is subjected to torture at the hands of states. And it has taken many years to include women's experiences of violence in work against torture, and to think torture as an appropriate term for a women's experiences of violence. And the focus here is, of course, on the perpetuation of the public-private divide, as, of course, it impacts women's rights experiences of violence. And I think this is also very important, and that's why I mentioned this general comment, but also the special rapporteur on torture in 2008 issued a very relevant report in this regard, which, as I mentioned, specifically highlights several forms of violence against women as torture, and criticizes this public and private divide that has rendered women's experiences of violence as not relevant, or not as relevant as other offenses. I would like to also mention that we included a definition of non-state torture according to the two activists that have worked in the field for many years, Jean Sarson and Linda MacDonald, which also worked with us in the project. And this definition emphasizes the occurrence of torture in various contexts beyond the state, including in the family, human trafficking, and also in the pornography industry. And we want to highlight non-state torture as a human rights violation, and also a failure to address women and girls' non-state torture victimization disclosures very seriously. Besides this, I would like to also mention, beyond the analysis of this article, we put forward several recommendations. As I mentioned, the report, it's supposed to be an advocacy tool and also a call to action. So I can give you just a few examples of recommendations that we find very relevant and are related to, for example, the need for member states to ensure that migrant women, refugee and asylum-seeking women do not face discrimination in any grounds, that the member states adopt the necessary measures to enhance the ability, for example, of undocumented migrant women to access their fundamental rights, but also the need for member states to adopt a child rights-based approach, but also to provide migrant women and asylum-seeking women and girls with relevant and accessible information and advice in a way, in a language they can understand. So this is very important, and something that comes across also from the interviews we did with the traumatology experts. And so this should also, of course, cover the right to interpreters, including sign language, legal professionals, and intercultural mediators. And we know that this is not the case in most countries. So this is incredibly relevant. Member states should also ensure the deployment of specific protection mechanism, for example, including places in women-only accommodation facilities, but also ensure access to legal advice and free legal aid. And yeah, so we have several recommendations that cover several thematic areas, but you can also, I think my colleagues already posted the link to the report, so you can also consult these recommendations. I would like to conclude, because I think we're running a bit, or we are on time. I would like to conclude just to say that This is very relevant for us. I think, as I mentioned, we're all very proud with this work that we put together, all the partners in this Fulfil project. But I think it's important to say that the EU has indeed a comprehensive framework of legal instruments dedicated to safeguarding women. And of course, the EU Charter is a cornerstone of this protection. So however, we know that its application often lacks the necessary nuance to address the unique circumstances of individual women facing discrimination, and particularly migrant women. So we need effective implementation of such approaches, and it's very important the collaboration between specialist women's rights organizations, and including those who focus on migrant women, and also state authorities. And it's only through concerted efforts and partnership that the EU can fulfill its commitments to equality, to justice for all women, irrespective of their background or legal status. And we hope this is an added contribution, and we can. This is a good effort to make this happen. Yeah. So thank you very much. Thank you.
Thank you very much, Mariana, for this overview. I indeed invite you all to go and consult the full report yourself, because, of course, in a short event like this, we cannot go in depth in every aspect of the analysis. We posted the link on the chat already, so you can just click on it, or you can also find it in the website of the European Network of Migrant Women. And soon, in the next couple months, we will also launch a website specific to the Fulfil project, where you will be able to access the first EU database specifically on violations, cases related to violations of fundamental rights of migrant women. So we also hope this will be a very useful tool for legal professionals across Europe tackling such cases. So we invited guest speakers today to also highlight the issue of fundamental rights of migrant women from different angles and perspectives. So I'm very happy to give the floor to Vasiliki Mukanaki, who is an expert in migration, and she also works in the asylum and migration sector of the EU Fundamental Rights Agency. The floor is yours. Thank you.
Thank you very much, Alisa. Good afternoon also from my side. I would like to start by thanking you for this invitation and for the opportunity to be here with you today, even virtually. The task of the Fundamental Rights Agency, called also FRA, is to provide data and evidence-based advice on fundamental rights issues to the EU institutions and to member states when they implement EU law. So definitely your report and this analysis is of great interest and value for our work. I took note of the recommendations, but I also look forward to the database that you mentioned. I'm a member of the asylum and migration sector of FRA, and my work has been mainly focusing on the migration situation at the external borders of the European Union, especially on the treatment of persons arriving to the EU in an irregular manner. FRA has worked on the protection of migrant women's rights in the context of various other projects, for example, as part of surveys conducted in past years with persons of immigrant backgrounds. But my intervention today will focus on FRA's current work, and specifically on two issues. The first one is the protection against gender-based violence in initial reception facilities at border areas. And the second one is a survey that FRA is conducting on experiences of violence or related human rights abuses against women fleeing the war in Ukraine. Concerning the first aspect of our work, and maybe to give you a bit of a background, in the last 8 years, FRA has been regularly visiting initial reception facilities in member states at the external borders of the EU, with the purpose to assess the situation on the ground when it comes to reception conditions, access to asylum, as well as procedures and their impact on fundamental rights. Following the approval of the Istanbul Convention by the EU, and the fact that it entered into force in October for the EU, FRA decided to carry out a round of field visits to reception facilities, focusing specifically on this issue, meaning on the implementation of the Istanbul Convention. EU asylum law already contains some provisions to protect women from gender-based violence, for example, when women are hosted in reception centers. The EU will also need to implement provisions of the Istanbul Convention that fall within its competence, including on matters relating to asylum and on refoulement. Some provisions of the Convention require the training of professionals on the prevention and detection of gender-based violence. They should also include staff working in reception facilities to allow them to correctly detect women who have suffered violence, either in their country of origin, during transit, or at their destination, including in the reception facility itself. Victims must have access to adequate healthcare, to social services. They must receive adequate and timely information on available support services, on legal measures, and all this in a language they understand. Now, to assess the implementation of these provisions, last December, FRA collected information from 6 initial reception centers. These included Purnara in Cyprus, the closed and controlled access centers in Kos and Samos in Greece, Messina and Pozzallo facilities in Italy, and Casa de Madre in the Canary Islands in Spain. The data collection focused on measures related to training, provision of information, vulnerability assessment, existence of women-only spaces, referral systems, and separation of single women from unrelated men. The situation was diverse and presented several challenges, and I would like to briefly mention some of those. We noted, for example, that awareness-raising activities for staff working in the facilities, including reception staff, security officers, cleaning personnel, on how to detect and respond to gender-based violence took place only in half of the facilities that we visited. In most of them, vulnerability assessments through which cases of violence or trafficking in human beings could potentially be detected did not cover every newly arrived woman. Even if these assessments were formally part of registration procedures, they did not always take place, for example, in periods with increased arrivals or due to shortages of medical staff. Another issue we noted was that referral systems for gender-based violence incidents were not adopted in all facilities that we visited, but in half of them. And most importantly, in some of the facilities visited, in periods with increased arrivals, single women were not always hosted separately from unrelated men. Security risks were also observed when accessing sanitary facilities, even though many of the centers we visited provided safe access to sanitary facilities with sufficient light or facilities separated from those used by men. Toilets and showers were not usually lockable, or there were a lot of damages in the infrastructure, like broken doors, etc., which hindered not only the privacy of women, but also increased the risk of assault. Also, none of the facilities we visited had dedicated rooms for women-only meetings or activities. Among the positive practices that we observed was the provision of specialized services to women by civil society support organizations or women's rights organizations in a couple of reception centers, or the policy in one case to accommodate single women in different centers from men. All these issues that we observed are just examples showing that it has been challenging for member states to ensure dignified reception conditions or the provision of support services, be it medical services, legal aid, or others, at facilities at borders, especially in cases when these facilities are in remote areas or in cases of prolonged stays of asylum seekers there. And inadequate reception conditions increase the risk of gender-based violence. Considering that the underlying logic of the new Pact on Asylum and Migration that has recently been adopted by the EU is to bring most of the asylum and return procedures at the external borders, so to keep new arrivals in border regions, this as such will inevitably bring new fundamental rights risks, including the risk of detention, difficulties in the provision of services, difficulties in ensuring adequate reception conditions. So in FRA's view, there's a need for a protective, sensitive implementation of the pact, as well as increased focus on the fundamental rights safeguards that it contains, including, for example, the explicit obligation for vulnerability checks, which is an important safeguard to detect experiences of violence, abuse, or trafficking cases. Another important safeguard is, of course, the obligation for fundamental rights monitoring during screening and asylum border procedures. And we believe that these safeguards should not be forgotten, they should be prioritized during the implementation of the pact. A second aspect of FRA's work that I would like to bring to your attention concerns a survey that we are currently conducting to collect experiences of women who have fled Ukraine and are now residing in Czechia, Germany, and Poland. The three countries were selected because they are among those EU member states hosting the largest number of women displaced by the war in Ukraine. The data collection will focus on experiences of violence and other human rights abuses which are related to the war and took place either in Ukraine or during transit or in the women's current country of residence in the European Union. The purpose is to examine the need for support or the adequacy of the existing support available to women who arrive in the European Union and are displaced by conflict. And the overall aim is also to contribute to efforts to collect evidence and effectively respond to violence and related human rights abuses. Interviews will be carried out with approximately 400 women in each of the member states that are part of the survey, so 1,200 in total, plus 30 qualitative in-depth interviews. And we are planning to publish the results in the course of 2025. I'll stop here. Thank you very much for your attention, and I'm looking forward to continuing the discussion.
Thank you very much, Vasiliki, for this presentation. It was very important for us to have the Fundamental Rights Agency represented today because for us it's extremely relevant to interact with the agency that is in charge of this framework and also to build bridges between the agencies and institutions in the EU level that are focusing on fundamental rights and the ones that are focusing on the framework of equality and non-discrimination, because the two are very much intertwined and sometimes we find barriers when we try to link them. So thank you again for your presence. I also take the opportunity of this transition to let you know that the event is being live streamed on YouTube and it's also being recorded, so you will be able to access it later on and also to share it maybe to other people that were not able to join us. Before giving the floor to the next speaker, I will also let you know that unfortunately we have had a cancellation. The member of the European Parliament, Juan López Aguilar, who was supposed to be speaking today, had a conflict with campaign-related activities that he's conducting in the context of the European election that are coming soon on the 9th of June next month. So unfortunately, he will not be joining us. So I will now give the floor to Ilaria Petrelli. We'll first give a brief introduction. Ilaria Petrelli is a senior research fellow at the Swiss Institute of Comparative Law, and she's also a council member of the European Law Institute. She's an esteemed expert in private international law, and she's also a licensed lawyer and former director of the Center for European Legal Studies. Ilaria has extensive experience teaching and conducting research across multiple countries, and her work focuses on family and succession law, human rights, and the evolving landscape of legal regulations. This includes contributions to significant international conventions and regulations. So Ilaria's research critically evaluates the role of private international law in addressing contemporary societal challenges. for us, it was particularly relevant to have your intervention today, Ilaria, because it brings a very concrete example of why we need this shift from a gender blind perspective in different sectors of the law in order to better respond to current situations. So without further ado, the floor is yours. Thank you.
Thank you. Thanks to you for your very kind introduction. And thank you for your excellent work, especially. I would like to convey two messages today. In addition of what I've heard, I'm really impressed of the work that's being done. And so the first thing I would like to say is thank you for the massive effort deployed by you, by the European Union, by the Fundamental Rights Agency, for improving the world society's governance with your intervention. So I see that the European Union in this, it's really the best, I think the strongest political actor today, because it is really guiding the most urgent and important legal reforms that are required now in matters that are very heterogeneous, like corporate social responsibility, parental child abduction and filiation, digital platforms. And I'm mentioning these because as it has been said before, in all these topics, we are seeing that the public-private divide doesn't really work in such a, there is, the separation is somehow becoming really outdated, and we need public and private actors together to enact that change that we need for migrant women's fundamental rights protection in particular. So impunity of corporation for crimes committed in the value chain abroad may sometimes be the very reason of migration towards EU countries. The complex legal framework of parental child abduction is dramatically gender neutral, and not only inadequate to protect migrant mothers, but really sometimes reinforcing their victimization, really undermining the chances to escape from domestic or other forms of violence. And also in the field of fertility treatments, we have the advancements of science, the very welcome advancement of science, have created a market where women are used to obtain eggs, a temporary rent of their wombs, and some of these women are transported to other countries for this operation or for the delivery of a living child. And again, and lastly, digital platform and social media have served as sometimes as Troy horses for new forms of obscurantism and violence against women. So first of all, I want to make it clear that all these phenomena, corporation, fertility clinics, and social media do offer immense opportunities for women empowerment. I will just mention the revolution brought about by the Me Too movement in social media. So these are not phenomena that are, I mean, we need to guide the evolution, the revolution that is that we are seeing by focusing on their impact that they have on women. And so your work is, for me, of paramount importance to guide towards this direction. And you mentioned that we want to see how gender-neutral legislation is impacting in a negative way women's rights. Yes, it's true, because this legislation is really insufficient to detect what are hidden inequalities, and hidden because they are these inequalities are so inside society that we don't even see them, because we consider them they are undetectable if we are not well prepared. Let me recall that in our common history, we have had legally recognized inequalities, like the legal incapacity of married women that was existed until 1938 in France, for example. Then paternal power potestas, it is common, it has been witnessed in the codes until the 70s, even in Italy. And so even if we have abolished in most of European countries these rules, and so we recognize women's autonomy as sociologists, when they give a closer look at families, they can attest, they can testify that, for example, family money is still not distributed or passed on equally to sons and daughters. So there is still in society a privilege of masculinity, which is, I want to stress that, this deeply rooted in all cultures. This is not something peculiar to certain culture that we can consider retrograde. This is a common heritage of mankind, if I may say so. Of course, it's something we want to get rid of. And I think that we are getting rid of, thanks to your work in particular, but also thanks to all the feminist movement that exists in all culture, in different culture, in different religions, and that are fighting for more equality. And so I would like to recall that it is in this time, 2024, that in Italy we are discussing on the surname. I want to stress that the devaluation of women, the subordination of women to men, exists also in rules like the rules on the surname. So one of the common reasoning was, or used to be, or is still sometimes in certain legislation, that of considering sons to be permanent members of the family, whereas daughters change families when they marry. This culture is justified by the fact that it's the father's surname that continues, whereas the mother's surname does not continue. Like my children, they don't have my surname, they have the surname of the father. And adoption is also used there is a change in the surname in most legislation on adoption. It's not just that they add up the surname of the adoptive parents, father or parent, to the original one. So all these ideas, all this legislation, they convey a proprietary concept of women and children. They justify it somehow. And this is, again, in all cultures. The second reason for a devaluation of women in society is violence against women, again. So violence against women is really a cause, but also a consequence of this proprietary concept of women and children by men. And here we need to recall the big step forward that has been made with the adoption of the Istanbul Convention, and that needs to be promoted. And here I would like to introduce a discussion on the concepts that are used in that convention, because Article 3 contains a definition that has been thought about and that has led to many controversies, because I would like to really stress that we need to keep the three concepts that are in the convention and Article 3 separated, because these three concepts are different and need different studies and need also different strategies to counteract violence. These are three forms of violence: so domestic violence, gender-based violence against women, but I would like to talk about gender-based violence neutrally in this case, and then violence against women. Why I think that this of course, there is an interrelation, they're interconnected, but they are different. So the first thing, domestic violence. Domestic violence happens in certain families. It's a neutral concept, and it has to be a neutral concept, because even though the victims of domestic violence are women in the majority of cases, this is a phenomenon that does not concern, I mean, it's interconnected with violence against women, But if we want a definition, we can only observe that it affects women disproportionately, but it can be the causes of domestic violence can be psychological causes that are also present in forms of violence of certain women against men. This is, of course, not very frequent, but it does exist. And so domestic violence needs to be explored by seeing in each family which are the psychological relational dynamics inside the family. And it is not necessarily a phenomenon that concerns women. Frequently, in the majority of cases, it comes from what I will call violence against women as an historical idea, but we need to explore it from a psychological point of view. There then comes gender-based violence. Gender-based violence. This is, I feel that this concept is very much connected with hate speech and with hate in general. And here it is the LGBTIQA+ community that is often very much affected by gender-based violence to the same extent as women. But again, this is another concept. What I study myself, what I'm focusing on is the third concept, which is violence against women in its historical and cultural dimension. This is really violence against women because they are women, because this comes from, as I said, a common heritage of mankind that we want to abandon. But before abandoning it, we have to acknowledge that it exists and not just reject it as belonging to another universe. We have it. The word family comes from the Latin, from the family were the servants of the family, and the patria potestas applied to all of the objects as well as the children and the women. And we had in our culture of Roman origin, this idea that of women that need to obey to men. And this duty to obey, which also makes it logically impossible to rape a wife, because marital rape is logically incompatible with the duty of women to obey, also explains that it's also connected with this idea of honor, women being the custodians of honor. And it's very typical of societies characterized by immobility of richness. This is something we want again to abandon, and for abandoning this, we also have to abandon this idea of, as it was said before, it has to be clear, the equality between men and women, the inexistence, of the duty of obey, duty to obey of women has to be really the focus where we have to be now. It's not sufficient to fight against coercive control. We really have to abandon the idea that there is a religious duty or whatever other is the source of women to obey men and have a subordinate role of women in society. And this, as I said, despite the adoption of gender legislation, still exists. But the good news is that all cultures, all religions are experiencing movements from women that come from feminists that want to promote women's emancipation from this duty. So it is the role, I think, of the EU to accompany these movements, especially as regards migrant women in the EU. These women may have a very special role as agents of change if they are properly assisted and helped. And also we have to stop their objectification, the objectification of all of us. I would like to conclude with an example, a concrete example of child abduction and or surrogacy. In both cases, I have to say, I feel that what legislation aims at preventing in the origin is a traumatic loss of references. So I would like to invite you to imagine yourself this thing that you are all living in a house, in a cozy house, I suppose, and you are surrounded by loving persons that are there for you. So imagine that abruptly, suddenly, this disappears and you find yourself in another house, in another environment with other people that are maybe also very gentle and kind with you, but you don't know anything about where are all the persons that were before, where is the environment that was there before. So this is the traumatic loss of any reference is what is experienced by a child when there is an abduction and possibly even when there is a separation abrupt from this environment. This makes me think, I don't know, I was thinking about it when I read Paul Auster's Travels in the Scriptorium. I don't know if you have read it, but yeah, it's really a loss of reference. And this was the aim when in 1980 the Convention against the Child Abduction Convention was drafted. So the terms were really gender neutral. This was also to conceal that its real target was undoubtedly gendered. But the idea was really to prevent in a mixed marriage when there is a father, and it was mainly fathers who were abducting their children to countries where they would be raised in a culture that they felt more safe for them, especially to protect the honor of their families. And I would like to stress that we don't have to think about these men as monsters, as sometimes they are depicted like. Of course, they are causing a very distressful harm to everybody, but I think the sufferance of these men was real when they are confronted to a new. So the advancement in equality will also benefit these men. So in 1980, the return mechanism was drafted in order to stop this traumatic loss of reference for the child as soon as possible, so that the child could be reintegrated in the environment where it was used to be and not derooted. In this case, this legislation was not protecting fathers enough, and so judges have corrected it in a way that now abductions are also include also the change of residence of the primary carer of the child, thus the mothers. And now, because of this shift, because of the enlargement of the notion of kidnapping, I could read phrases. If you go to the site of the Hague Conference, where they have the statistics, you can find, even in the most recent one, the phrase that in 1980, when the convention was drafted, there was the idea was that the majority of abductors were fathers. Today, we are seeing that the majority of abductors or taking persons are mothers. When I first read that, I said, wow, what is happening? Why are the women becoming? And then when you disaggregate the data, so when you add a gendered dimension to the data, you see that it's still true that the majority of abductors are fathers, in the sense that when there is a real child kidnapping, a kidnapping in the proper sense, when there is a commando, because there are specialized commandos for parental child abduction, when there is a commando that goes in the school where the child is going and gets the child, put him in a car, then in a plane, and flees, those abductors, the majority of those are fathers. And when you see the taking mothers, the story of the taking mothers, in most cases, these mothers are preparing a relocation, but they don't have the consent of the father to relocate. And you see cases as mothers finding a job, having better opportunities in life, also like 40 kilometers, as it happened in Switzerland for a French mother who was condemned to return to France and then lose that job opportunity because the judge didn't give any evaluation to the fact that it was an illicit transfer. The child was prepared to change. And so this is to say that we need to add a gendered dimension to see the real reason behind an abduction before, in order to see if a return is really needed and as is a useful provisional measures, because it is in a way or not. Sorry, I took a long time, but I'm happy to. I hope that you have understood the message, and I'm available for any question.
Thank you very much, Ilaria. That was very interesting. I see that some of you are already using the Q&A, how do you say, feature in Zoom. So this is good. You can keep asking questions and we will get to the Q&A very soon. You can also ask them in the chat if you want, and or we will give you the floor if you wish to. But in the meantime, I will give the floor to Anna Zobnina, who is Strategy and Executive Director of the European Network of Migrant Women, and she will give us concluding remarks.
Hello, everyone. Thank you so much to all the presenters. Thank you, Alisa, and thank you to Mariana and Alisa, especially for doing monumental work in preparing, researching, and drafting this report that took us many months. And initially, I do not know if this was mentioned, we did not plan to produce a 70-page report. The initial idea was that we would kind of have a short, let's say, fact sheet outlining certain problematic areas of Charter, the EU Charter of Fundamental Rights, being treated as an instrument that kind of almost not applicable to women as women. In the course of the preparation and research and looking at legal cases, but also, as Mariana mentioned, speaking with, we distributed a survey to legal practitioners, practicing lawyers mostly. What became clear is that the application of the Charter is very low generally. Understanding of the Charter is very low. Understanding of its relevance to legal cases. And of course, we were specifically probing on the questions of, do you use the Charter? What articles of the Charter you use in cases of migrant women? So it's not the overall application, but specific cases of migrant, refugees, asylum-seeking women, also women from the European Union states when they migrate from one state to another. It's also kind of falls under our definition of migrant women, in difference to the definition used by the European Commission or European institutions, where they would define third country nationals who are migrants, and then EU mobile citizens who are kind of not really migrants. That's not the approach that we take. So I just wanted to clarify this. But also, so in the course of this survey, two issues became apparent: that the Charter itself is not very known, and secondly, it is not applied in relation to the cases that we are interested in, which is migrant women. What also became apparent in the course of kind of preparation, and what motivated us to write a longer document, is really a remarkable erasure of women from the legal discourse as such. And now please excuse me, I'm not a lawyer myself. I'm not a legal professional or practitioner. But I do, by the virtue of my work and my position and my experience, study and spend a lot of time on studying legal instruments. Not all of them, but those who are that sit in two areas: women's rights and migration and asylum and integration. And what we realized through some kind of historic investigations is that there has been, on the one hand, a remarkable progress in a way that the European Union as a whole has built not only the corpus of laws and policies, but also jurisprudence and case law on women. But at the same time, a remarkable kind of forgetting of those cases and not really using them and not relying them. And not invoking them, for example, when it comes to the cases of migrant women or asylum-seeking women. I mean, if you look at for example, the disparity between men seeking asylum and the grounds on which they seek asylum compared to women, it's absolutely very, very clear that, first of all, it's hugely disproportionate number. Applications, the cases, the success cases, especially first ones, because women are more successful in appeal, it's overwhelmingly men. And something interesting also came up, and we put it in the report. So we speak a lot about gender neutrality. It's a little bit vague term, I think, unless experts use it with a very clear understanding what it means. But for us, the meaning is quite simple. It's the laws or policies that completely overlook specificities of women's situations, women's needs, women's vulnerabilities. So this gender neutrality, when we invoke this concept, it is opposed by two concepts that are present in legal terms, which is what is known as gender mainstreaming. And again, I would invite everyone to use these terms with an understanding, because what we observe that there is a lot of gender expertise and gender this and gender that, but we need to understand what we mean by those terms. But also there are positive measures. So it's not just about mainstreaming certain concepts, and in this case, let's say mainstreaming the understanding or analysis of inequalities, structural inequalities between women and men, between the two groups in society. But there are also the positive measures that are both mentioned in, if we start from CEDAW, we have a specific Article 4 in CEDAW that speaks about specific measures dedicated to the eradication or correction of historic structural disadvantages that women as a group have faced. And CEDAW is very clear that those measures in no way should be treated or understood as discriminatory, because their very purpose is to remedy, correct historic inequality. And that for this reason, they're called temporary, because in an ideal society, those measures would be put in place for a period of time. And then once the situation has been corrected, they can be removed. So we actually do not see a lot of those measures, but also looking at some of the reports of the European Commission, what we understood that the positive measures or temporary special measures, as CEDAW calls them, they are really poorly understood at the state level, in a sense that they have very different interpretations. They have very different names, very different translations, and very different meanings in a way, what kind of laws they are. And so when we come to migrant women, the situation is especially difficult, because literally and practically in every case that we have dealt with on paper, it is always an intersection of several frameworks. So there is obviously a very strong framework of non-discrimination on the basis of sex in the European Union. And it needs to be involved, at least we need to have it at the background of our thinking when we deal with the cases of migrant women. Just to give you a small example, we have, for example, domestic workers. in domestic workers complaints, when they exist, the labor complaints submitted when a woman considers that she was discriminated at work, and the work would be her the house of the employer. In a very large number of those cases, apart from what would be understood by this woman as a labor discrimination, there is actually sex discrimination inside, because there is sexual harassment, and sexual harassment is a sex discrimination according to the European law. But this is never, almost never understood as sex discrimination in the case of domestic work. And this is just one example. And speaking of this, of domestic work, we had recently a rather brilliant ruling from the EU Court of Justice on Spain, where CEDAW was used, as a matter of fact, to hold Spain, the state of Spain, accountable for violation of the rights of domestic workers as a group who are women. They were recognized to be discriminated on the basis of sex because they had less access to certain, if I'm not mistaken, that they didn't have access to benefits, and there was discrimination and payment. But the logic of the ruling was such that they were discriminated not just because they're domestic workers, but because those domestic workers, in their overwhelming majority, are women, and they're discriminated, therefore, as women, as a group. And this was a very interesting ruling for us that we also are using in the training that the members of the project are conducting right now with legal practitioners in Italy, France, and Portugal. And also there are two kind of EU-wide trainings that are delivered by European Women's Lawyers Association on strategic litigation at the European or EU level. So those are the things that I wanted to mention as pertinent to this particular conversation of women's rights perspective on fundamental rights. And as Mariana mentioned at the very beginning, we care about language, we care about terms, we care about naming things correctly, because if we don't do this, it can lead to quite negative consequences for women. And Vasiliki from Fundamental Rights Agency did mention the new migration pact. And as a matter of fact, this kind of linguistic inconsistencies, they also observed there, apart from many other issues that we have with this pact. The fact that there is no mention of women. So the pact is made of how many? 10 legislative acts, smaller document, and there is literally practically no mention of women, and which is quite extraordinary considering the history of this is what is known as gender mainstreaming or positive measures in the European Union. How come we're still in the situation when we have 10 legislative packages passing through the European Parliament, and here there are some mentions of vulnerable groups. There are some mention of gender-based violence, which legally speaking is not the same as violence against women, because anybody can be a victim of gender-based violence. And we're basically in this very bizarre neutral situation when we have this legislative package on the table, debated, voted, completely omitting the needs and specificities of women, apart from just lumping the women with something called vulnerable group. For us, this is never enough. We want much more specific language. We want women and girls as well, according to the Istanbul Convention that defines the, the woman as they describe it, also includes females under 18. We want those measures to be specific, and we want, apart from mainstreaming this principle of equality between women and men, we want positive special measures, standalone mechanisms, including allocation of budget, including indicators, including follow-up mechanisms, and understanding how those measures were implemented with regards to women migrant women in our case, refugee women, asylum-seeking women, and undocumented women as a group. I'm going to finish here, and I will pass the floor back, I think, to Alisa. And if there are any questions, we'll be very happy to answer them.
Thank you very much, Anna, and thank you to all of the speakers. I also want to mention that in the context of the Fulfil project, we have built a cross-border network of EU, let's say EU-wide network of legal professionals. This is a network that meets every month in order to receive a presentation on a specific aspect of either EU developments, at policy level or something specific in EU member states, but it's always relevant to migrant women and their access to justice and fundamental rights. So usually, so far, we have had a presentation either of specific cases or thematic presentation from the partners, the members of the consortium of the Fulfil project. However, we also want the members of the network themselves to bring new topics and presentations. And in fine, our goal with this network is to have a space for legal professionals to really share knowledge, seek support with one another, and maybe find opportunities and synergies to also engage in strategic litigation with regards to migrant women access to justice and rights. So if you are yourself a legal professional and you would like to be part of this network, I will send the link to register in the chat. You just have to click the link and to fill a few questions in the form, and then you will be contacted with the date and the link for the next meeting. There are monthly meetings. They happen every last Friday of the month, and we alternate between 6:30 p.m. and 12:30 p.m. so that everyone can attend. The second information is that I mentioned before the case law database that will be published in the month to come as part of the deliverables of the Fulfil project. So this database, we also are very excited about it and to be using it because it's easy to use tool for legal professionals who want to find case law and jurisprudence in order to bring more weight to their legal argument or to find information. For this, we are still gathering cases, and also we will be updating the website continuously. So we also have a form for this, for the collection of case law. I will also share it in the chat so that if you have a relevant case in your country that you are aware of that relates to a violation of a fundamental rights of migrant women, we also extended it to families because many cases concern a mother with her children, for instance, or that kind of thing. You are, of course, more than welcome to let us know and submit it through the form that I will share, and that way we can include it in the database. Thank you so much, everyone, for your attention, for being here. And now we will give the floor to you and to your questions. You can keep using the question and answer feature. You can write in the chat or you can raise your hand. I already see 2 hands. And I will give you the floor so that you can take it and ask your question to the speakers directly. Thank you, everyone. I have sent the link in the chat, both links, and I will now give the floor to Veronica Lupu, who is, by the way, a member of our network of legal professionals. Veronica, the floor is yours. By the way, participants cannot turn on the video because of the parameters of the meeting, but normally you can speak. Okay, if Veronica cannot speak, maybe we can go to Indira.
No, normally she can speak.
Veronica, can you hear me? Indira, can you speak? Okay, if you have an issue turning your microphone on, can you say so in the question and answer feature. I see that Indira has already written. Okay, we have 3 people who want to speak. Maybe we can put them co-hosts just for the time they ask their question, Anna.
But they already are. They are on top in the panel and they're unmuted.
But
Veronica, you can speak. You can speak if I do not know if there's an issue.
Hello, do you hear me?
Okay.
Yes.
Yes, we can hear you,
Hello,
Veronica.
sorry, some troubles. Congratulations for such interesting, important event, and thank you for your speakers. Really very important for us. I wanted to just Alicia mentioned about some cases. I think it's very important for us to have these cases and to, how to say, difficult, to work together in some cases to find solutions according to charters. I think it's good for practitioners to know in some cases how to find solution according to legislation, European legislations. So this is a practical exercise, but maybe it's reason to see how we can maybe in online event to discuss and to make some debates on how to find solution for cases. If it's possible, if it's acceptable. Thank you.
Thank you very much, Veronica. Does anyone of the speaker wants to react to this? Otherwise, we can. Okay, Anna, go ahead.
No, sorry, I did not understand the question. How can we use the database practically? Was this the question?
I think it was more a comment than a question. Go ahead, Veronica.
Yes, I mean, if we have some cases, like Alicia asked us if we have cases to send to you. So if it's possible to have 2 or 3 cases and together to find solutions for these cases, according to European legislation, according to chapters.
Okay,
like I can discuss about trafficking case, how we can apply, because we have no from Moldova case on the European Court of Justice. Even they are very difficult cases. So to find together a solution to make a practical exercise like simulation.
Yes, I understand. So this, technically speaking, would fall outside of the current scope of this specific project. What we're doing is not really the practical solutions to, it is not a litigation, and just to be perfectly clear, the European Union who funds this project is not funding the work of lawyers in courts or anything like this. We welcome in the database absolutely all cases. It doesn't need to be one. There's no limitation. We want to collect as many cases as possible because the database will be live and it will be updated on an ongoing basis after we launch it. But when it comes to practical exercises, we can think maybe about the potential future steps that we can take together with the Legal Practitioners Network, maybe conducting some exercises. But for the moment, what concerns the database specifically, we're just collecting the cases to make them available, to build this body of knowledge. This is the main purpose of building this database at the moment.
Thank you very much.
If I may add on this, we also have built, like I was mentioning before, a training program, Fulfil training program. There are several modules. Some are dedicated to and tailored to migrant women and civil society organizations or professionals working directly with migrant women. But there are specific modules for legal professionals wanting to know more about the EU Charter of Fundamental Rights and or migrant women specific situations. And for this specifically, there are practical exercises on strategic litigation and on the charter, and we use actual cases that are anonymized, and we use them through case analysis and simulations in order for the legal professionals who take part in the trainings to really apply basically the knowledge and information that we're giving, and also brainstorm and strategize together and maybe exchange good practices and so on. For this, we have had already several training sessions. They are conducted by our partners in the countries that I mentioned before, the countries of the project. So that's Portugal, France, and Italy. And there are also EU-wide sessions that are conducted by the European Network of women lawyers. So you are, Veronica, yourself in the network of legal professionals, so you will definitely get the information for these sessions. And anyone who is interested can let us know. I will also write the generic email address of Venom in the chat, and we can put you in the loop as well so that you can attend these sessions.
Thank you very much.
Thank you, Veronica. So let's go to the next speaker. Oh, I don't see any hands anymore. Jeannette or Ginette, you wanted to speak, and also Indira, I think. So you can take the floor now.
Can you hear me?
Yes, very well.
Okay. Yes, I got to thinking, since this is policy guidance with regard to the United States, I'd like to see this sent to the CEDA committee, since the United States does not have CEDA, and also to the Department of Justice and the U.S. State Department. I think it's very, very important, and I think it would give traction in the United States to how important is that we get on board and pass and fully ratify CEDA. You know, as looking at basic human rights, because in this country, there's no education on the Universal Declaration of Human Rights. Most people don't know what CEDA is, what it does, nothing like that. They mostly depend upon what comes out of our criminal justice system or the Supreme Court. And I would say the US Supreme Court should probably also receive this document. So thank you very much for all of your work. And I'm just asking, we need help in the United States. Thank you.
Thank you very much, Jeanette. So I want to say that the report that we presented today is very specific to the framework of the EU Charter of Fundamental Rights. However, of course, the fundamental rights that are protected in the Charter are also protected by numerous other instruments that are also mentioned in the report in a way that is very interconnected. So like I told you in my response to your comment previously, Jeanette, I'm happy to, and we are all in the consortium of Fulfil, happy to discuss if there are specific contacts that could benefit from us sending this material. We would be happy to support. So don't hesitate to reach out to me by email, and we can discuss. Thank you. I don't know if other people want to take the floor. Thank you all for your comments through the event. I have tried to respond as we went. If you still have other questions or last comments before we close the meeting, feel free either to write them or to take the floor, to raise your hand. Otherwise, we will close the meeting soon. We are a little bit early, but that's fine. We're all busy, so we can go to our.
I think, Alisa, I think we have a question in one question in Q&A.
Okay, so we have Sylvia Catalan, who wrote, "Thank you to all speakers. This webinar gives a platform to learn more about intersectionality and migrant women's rights. In Italy, there are many difficulties and human rights abuses in the current climate, sorry. So the question is, how can entry-level practitioners aid efforts in promoting this message? Ilaria or Vasiliki or Anna, would you like to respond to this question?
I can follow up, but maybe I would like to give the floor to others. I don't know, Ilaria, do you want to say
I can take the question. I think the work of the practitioner is paramount because if nobody, I mean, if there's somebody who can raise the issue, can use the arguments, it's the practitioner in front of the court. I mean, the judge could we lack also of appropriate training on the vocabulary as well. I think that I agree with Anna. The words are really important, and to me, as I said, the most important is really to focus on the historical reasons that of violence against women. But nevertheless, it's the practitioner who has to raise, who is in the position to defend his case by using, by gender mainstreaming the legal issue instead of using neutral rules. So I don't know if I answered, but.
Thank you very much, Ilaria. Anna, you also had some comments to make?
Yes, I just wanted to say how very sorry I am that our chair, who is a lawyer herself, and the legal practitioner is not with us. She was supposed to give a welcome speech, but and the reason she's not with us is because she is right now in court on the case of undocumented women. And not to speak on her behalf, but my understanding that from speaking a lot, and first of all, there are not many feminist lawyers, and this is a very big problem to start with. I think that when we come to the point when someone becomes the entry-level practitioner, the beginning practicing lawyers, this is already where we see a very big lack of those professionals who come out of universities or passing their bars with an understanding of this importance of thinking about women as a group who becomes discriminated for specific reasons, and the arguments, how they develop and what they apply in court. I think that, again, with a disclaimer that I'm not practicing in courts myself, but from exchanges that we had in this group of legal practitioners that we managed to build, and the members in the partnership and Fulfil project, I think it does take time, and it does take training. We are quite concerned about the fact that there are so many specialists who proclaim to be specialists in women's rights, but actually without actual legal specialist knowledge. And I think it is not kind of knowledge that you just acquire through a 2 hours, certificate. It does require substantive studying, and not only of legal issues as such. The whole point, and this is what we have in the report, that there is kind of sociological, anthropological, if you want, perspective, historic perspective, and of course the feminist perspective that we apply. We ask the questions. The question primarily is quite basic. We would ask, is this law, or is the way this law is applied, is it good for women or is it bad for women? And very often we find that either the law itself or the way it is interpreted actually is not beneficial for women. And I think it's an exercise in its own right to not to become a feminist lawyer, which is like a big thing, but to just learn to ask the questions about women. Because very often, and even in today's presentations, I have to note this, we feel that it is our obligation, it is our duty, almost moral duty, to always mention men as well. We are saying these women are raped, women are trafficked, women are this and that. And then with an addition, but men, blah, blah, blah. And I think it is almost a psychological exercise for women to leave it outside. There's no other group at all who is subjected to this kind of treatment, that they always have to be in an addition or together with some other group. We are the majority of the human population. Migrant women are at least in some cases more than 50% of migrants, and we're perfectly entitled to have a conversation just about us, just about women's rights. And the more we practice it, the more normal it becomes. Also, I believe, in the place such as courtroom. So this is, maybe Vasiliki wants to add something. She put her camera on.
Yes, it's not exactly a reply to the question that we received, but I felt the need to also praise the work of practitioners, because most of the information on cases that we receive, based on which we build the advice that we provide to institutions, come from lawyers and other practitioners. So just to say a big thank you and continue the great work.
Thank you very much, all of you, for your responses and your remarks. Now we have Linda McDonald, who would like to ask a question or to make a comment. You can take the floor, Linda.
Thank you, Alyssa. It's more of a comment because I'm Canadian and I'm working with these marvelous feminist lawyers and activists and advocates. I can't express how proud I am to be part of this group. It's so moving for me. And as a Canadian, I've learned a lot because I didn't realize that Canada has a seat on the EU Commission. So, you know, I'm thinking that now Jean and I, after pushing so hard in our country to have non-state torture recognized as a crime in Canada, we can use this powerful document, this brilliant document, to push our country more into that direction, because as member states start recognizing how much non-state torture there is in the world against migrant women and all women. And I agree with Anna, we don't have to compare us to men today. I'm talking about women, and proud to be talking about women only, because women's spaces are shrinking, as we know. So I'm just overwhelmed with the brilliance of the feminist lawyers and women's voices here. It's a historic occasion, and I just want to say we can't ever forget that we're talking about patriarchy. This is the battle we have, is patriarchy. This is the foundation of the structures of our social relationships. And until we get rid of patriarchy and the hate that it perpetuates, we'll never be free as women. So this is a big piece, a historical day in that block of taking some of patriarchy away. And I thank you all for your caring and just your persistence.
Yeah.
Thank you very much, Linda. Go ahead, Ilaria, please.
I just felt, yes, I'm with the last comment, and also I would like to add on the lack of feminist lawyers practitioners, because this, I think, it's really due to the structure of legal studies, at least in the countries where I have studied, which are France, Italy, and Switzerland, where the model of patriarchy is also transposed in the academy, because you have a baron, which is always, I mean, I'm here well, I would not say, but there is this model. There is the old white professor, and I've been blocked a couple of times in my careers, even more, by this very important guy. And so I do agree. I would like to say that to me, it's very important to convey a message of unity in the struggle. So I mean, my views, like I did today before. It's really about having everybody on board in this feminist struggle, and do not be afraid of women. Do not, because otherwise we have all this representation. There is an history of misogyny too, and we have all this representation. But I really think that it's important to also have a certain men, a minority of men, on board, and that's why I do there. I often, I have to say, but I will reflect on your invitation, Anna, to maybe not even pronounce the word in an entire intervention, because it's true that it happens. And today I recalled on the surname, I just want to add a little anecdote, because I was attending in Italy, we are discussing now on the abandon of the father's surname, right? My daughters have always asked me, why do you have a difference? Are you from another family? So, and there was this speech of this colleague of mine who said to the senators, to Italian senators, listen, now in Austria, for example, if the parents do not agree on the surname, it's the surname of the mother that is given to the child. And there you have this male senator just intervening very spontaneous. Oh, but now we exaggerate. And she didn't have the promptness to react by saying, and what about until now? She said, yes, of course, this is an exaggeration, because we are so not used to think about the possible reverse. That no, I think I mean, the balance has been like this for men for thousands of years. So if we have a moment like this with positive action, it's just because we want to have a rebound. There's no will of domination. At least I think there's no will of domination of men, at least on me. It's just a matter of having, I mean, analyzing data in a way that they show the reality, and not like in that phrase that I recall, the majority of abductors are mothers. Well, so I just wanted to add this. Thank you.
Thank you very much, Ilaria. Thank you all. And we have now one more question in the Q&A. It's from Pierre Alfonso. The question is, how does the European federalism, in case of being approved, can help migrant women in the respect of their fundamental rights? Is it an opportunity according to you or not? So I don't know who would like to take this question. Do you think the idea of a European federalism basically would help promote migrant women's rights or not?
I think it's a very difficult question.
Yes, it is.
It's not only perhaps because personally I lack the knowledge in the different potential legal structures of the European Union and the federalist model. But also I think that the member states themselves in the European Union are in such dramatically different places. I think it's impossible, no matter what kind of how the European Union bloc looks in terms of its like legal functioning. You know, we have now the whole discussion about how the Council of the European Union adopts decisions, because it should be on the principle of unanimity, but we want it to be democratic majority and so on. But when we look at the current political climate, migration policies, asylum policies, including the newly adopted Migration Pact and the principle, the very contested principle of solidarity between the states. I think it's very difficult to make a prediction. And I think historically we have precedents when some of the very well-intended legal solutions turned against the group that we envisioned that they would benefit. I think very much when it comes to the rights of migrant women, or violations of the rights of migrant women, and we have to look at different groups. It's even though we use this term migrant women, but as I mentioned before, there are huge differences in legal rights, legal status, and to what you're entitled to as a migrant. So we can have a separate conversation on those different groups, but it would very much depend on the individual current policies and treatments and application of non-discrimination laws at the state level. How states are treating migrants and refugees, and how states are treating women and girls. Sorry if it doesn't answer the question, but this is kind of my general idea about it.
Thank you very much, Anna. I don't know if Ilaya and Vasiliki have comments. Otherwise, Jeanne is making in the Q&A a comment about the importance of the use of terms, which was also, as Mariana mentioned before, a big focus for us in the writing of the report, which is why we added a glossary of terms at the beginning in order to start when people are reading the report, they understand the terms that we're writing in the way that we intended to, because we find that when we engage in debates or in different types of analysis, often the misunderstanding or the disagreement will come from different definitions of terms. And it's very important to know what we're talking about, to use the proper words. So for this, I invite you to look at the definition section of our report. Jeanne would like to share a point. Of course, go ahead, please take the floor.
Thank you, Elisa. I've been working on a paper, and as I'm working on it, I'm learning more about the use of the term victim-centered. And what I'm finding is that often when that term is used, there is already a discriminatory application in the fact that it is applied in a way that it assumes that the person who's been victimized has already had the right to charge a specific perpetrator. And what I'm learning is that there's a built-in discrimination in the definition because of that reason, because as we've learned in this work, the Fulfil project, that migrant women often do not have the right, and certainly around the issue of torture victimization by non-state actors. That is very rarely identified as a crime anywhere globally. So we are breaking really massive ground around discrimination. And also in doing so, I think, I'm not sure if anybody has commented on the issue of due diligence. When we start breaking ground, we start pressuring state parties to look at the due diligence. So I just wanted to make that comment about understanding the terms we use and really how to look at them to see how much discrimination and lack of due diligence there is. And thank you all for all the work that this has entailed, and I'm just hoping it filters from migrant women to all women on the face of this planet. So thank you very much.
Thank you very much, then.
Yeah, maybe
yes,
on terms, yes, because the other problematic term is vulnerability, because when you refer to a woman as vulnerable, sometimes you can also help convey the message that a woman needs protection, which is of course not what we want to do. They are sometimes in difficult position and situation, but it's not that because there is an inherent vulnerability. Well, there is in the case of because they are subject to violence, and because of what we, I mean, some certain feminists, as McKinnon have pointed out, there is a sort of genocide, that we can understand violence against women as genocide, because the continuous threat of violence has somehow made the women vulnerable, but we want to move on and leave that also behind. And so it's the situation in which they are that has to be addressed, not So yes, this is another avenue of research that is being searched, how to help also with terms to empower women in society. But there is a long way to go, and so we have just to roll up our sleeves and select the. And your project, of course, is an excellent way to move forward.
Thank you all. I think, oh yes, there is one last question. What would you say instead of vulnerability?
So some people use fragile, which is fragility, but I think it's another also tricky word. I think you have to describe the situation more than the woman, because the problem is the situation in which the woman finds herself because of these very social structures that really are difficult to win. And also many women do not realize the stereotypes in which they live and they agree to live. So it's yeah. I don't know, Anna, I think you wanted to add something.
Yeah, it's just we use normally in the network, we had this discussion many times. We try to avoid saying vulnerable women or women as we don't want to attach the vulnerability as a label to woman as a subject as such. But we normally use situations of vulnerability, women in the situations of vulnerability, and we find it most helpful to be specific what we're talking about. And there are, of course, so let's say pregnant women, we can assume almost that that's why CEDAW, for example, speaks very specifically about the status of women as mothers. And there is a tricky fine line between starting stereotyping women as reproductive machines, who are designed to carry babies, and protecting their status as mothers or as pregnant women under law with specific, actually, they don't even need to be temporary, because this is not, we don't have a solution on how to reproduce differently yet on this planet, and women require a differentiated treatment. This is how we normally call it, like legal terms. It is not inappropriate to have specific conditions for women who are pregnant, for instance. And this is why, again, in the situations of vulnerability, which would be absolutely a woman on the move, a woman who is fleeing violence or moving for some other reasons, this movement in itself creates vulnerability. When woman is in a refugee camp is never a safe environment, no matter how what kind of guards we put there. It is basically close to a situation of detention, very similar to deprivation of liberty. In some cases, it is actual deprivation of liberty, but also the living conditions, the absence of privacy, the issues with like toilets that very basic, but very important, that Vasiliki was mentioning, that exacerbates risk of male violence. So all of those specific situations that create vulnerability for a woman, that under different circumstances, she might not be vulnerable in this case.
We also use at risk. So this also helps us go away from the word vulnerability, and also illustrate the fact that in a given situation, the women will be at risk of violence or other situations. In the Fulfil project, and especially in the framework of the training, we have used culturally and legally constructed vulnerabilities. And for us, it was very important to frame it like that, to also make the trainees, so the legal professionals especially, understand that the law itself is also constructing to some extent the vulnerabilities of some people. When there is, for instance, no independent legal status for a woman who joins her husband through family reunification in Europe, then it creates legally the vulnerability of this woman towards her husband because she depends on him legally, administratively, and therefore it creates also the ground for maybe abuse and violence. Regarding this terminology, I also think while it's important not to essentialize women and associate always women with vulnerability, I also think sometimes we should not shy away from the words because they do describe situations that exist and they are reality, and we have to be able to mention it. And when I say this, I think specifically of the word victims. I have heard for years and years that we should not use the word victim because it's too negative and women are not victims, we are survivors, etc. However, we live in a context where most women who go through violence, especially sexual violence and rape, do not always acknowledge that they are undergoing violence because it's so normalized in society, especially in the context, for instance, of marriage and so on, that the fact of recognizing someone as a victim, first of all, a victim has rights, and also a victim has, if there is a victim, there is a crime, so there is a perpetrator, and there is the ability to seek for justice. Also, in a healing process after going through abuse and violence, being recognized, for instance, for a court of justice as a victim has been proven to be very helpful in terms of healing and reconstruction. So for all of these reasons, we should both not shy away from the words, but also be very specific in the way we use these words and really make the point that we want to make with it. We're arriving to 4 p.m., which is the hour of ending to our event. I'm just checking if we have some last comments. Some women are commenting in the chat that they use the term crime victims, for instance, or survivor of criminal violence. So all of this is in the same wavelength as what we were mentioning. So thank you. Someone teaches trainings on how to do vulnerability analysis. So yeah, that's also very important. That's something in the Victim Rights Directive that is currently being revised. There is something about, it's called individual assessment, that is the same logic as a vulnerability analysis. It's very important that there is an acknowledgement of the vulnerability factors of each individual when they go to the police, to the law enforcement, in order to be able to give them a specific protection if needed. Yes, so thank you everyone for your attention, for your comments, for your questions. Thank you especially to our speakers. Thank you, Mariana, unfortunately was not able to, she had to leave because she's traveling today. But thank you to her for presenting our report so brilliantly. And we hope that this gave you the will to go through it, to read it, although it's 70 pages. We hope it will be useful to you, along with the other tools of the Fulfil project, and notably the case law database that we are looking forward to share with you. I don't know if our speakers or Anna have any last words before we part ways.
I just want to say thank you, and thank you to you for producing so much work and for moderating this webinar today, despite the fact that you are quite sick, that I'm aware.
Thank you.
And yeah, just maybe the last floor, maybe Ilaria and Vasiliki wants to say something.
Okay. Yes, no, thank you very much for your work. It's I think it's very, very important, because even in commentaries that I went through for the Istanbul Convention, you find sometimes difficulties in proper understanding of women's rights. So thank you very much, and I hope that there will be other projects fulfilled in the future. Thank you.
Thank you, Ilaria. Vasiliki, go ahead.
Just a thank you also from my side, not just for the discussion today, but also for the report. I found it extremely interesting and valuable. So thank you and good luck with your work in the future.
Thank you very much, all of you. So we will close the meeting now. If you have follow-up questions for us, you can reach us at info@migrantwomennetwork.com. migrant.org. So please feel free to reach out and to join our network of legal professionals, to submit cases, to read the reports, and we hope to be engaging with you very soon. Thank you all.